All right, we are now going to be discussing Note 6, which deals with easements. I will feel somewhat constrained in doing this by video. This is one of my favorite topics to start putting all kinds of diagrams on the whiteboard for you, but I don't yet feel adept enough to set up a whiteboard and to try and video myself putting different diagrams and pictures on the whiteboard. So we'll have to try to verbally carry out what I would have in the old days done in dramatic, artistic fashion in front of all you guys as you sat there in wonderment looking at what Professor Walsh was scribbling and drawing on the board. All right, remember, as we talked about last time, the concept that ownership of real estate is this idea that there are all kinds of legal rights attached to the real estate, and any person can hold a bunch of them, and those rights can be taken out and given individually to third parties. And that is the whole essence of an easement. An easement is a non-possessory right to use the property of another for a particular purpose. Non-possessory means you don't get to sit there, you don't get to occupy it, you're not putting your house there necessarily. You are doing some other thing. And 99.9% of the time, the easement is to give ability to get from one piece of land to another. There are many types of driveways that are easements. There are many types of easements for water pipes, sewer pipes, electric lines, cable TV lines. And the idea is that we may have to get access to a piece of property for any of these services or for people and vehicles to come and go. We may have to cross over the property of another. And in doing so, an easement defines what the rights of each party would be in that situation. Most easements are what we call appurtenant easements. And a pertinent easement is one where the two pieces of property involved are directly next to or adjacent to each other. An example of this would be on the east side of Providence. A large number of those very big and beautiful, expensive houses were built before automobiles existed. They have very narrow yards, and nobody planned for driveways. Very often, to get into the back of the property with a vehicle, you will need to drive over your neighbor's land or a piece of your neighbor's land in order to facilitate that process of parking your car behind your house. And usually, very often, you'll find on the east side two houses that are on pieces of land adjacent to each other. There'll be a driveway that goes up between the two of them, and that driveway then splits out in the back so they can each go to their respective garages or parking spaces at the back of the buildings. In that type of situation, each side actually has an easement. So let's say the driveway is 10 feet wide, 5 feet is on one lot, 5 feet is on the other lot. Each piece of property has a 5-foot easement on the land of the other lot to allow them to go back and forth to get their cars and vehicles and to walk up and down, to push their bicycles or their baby carriages, walk their dog up and down to get from the street to the back of their yard. That would be the perfect picture of an appurtenant easement, two properties next to each other, and in that case, it's a mutual easement. Both properties are subject to the easements. Both properties benefit from the easements. Now, there can also be situations, Providence and Pawtucket and Central Falls were famous in the late 1800s for letting people build 2 and 3 buildings on one piece of land. So that you would have a house on the front of the lot right at the street line, and then they would build another house in the backyard. And over the years, people didn't want to own 2 buildings. These became separated. People split up the lots. But the lots in the old days were very narrow. There wasn't a lot of space, and usually what would happen is they would just draw a line across behind one house and cut the lot in half. The back lot would then need an easement across the front lot in order to get to the street, again for cars, just to walk even, and certainly to run utilities, water, sewer, electric lines. In that type of situation, the back lot would be called the dominant estate because the easement benefits the back lot and not the front lot. The front lot we call the servient estate because it is subject to this easement that benefits the people in back now, but doesn't really do anything to help the front lot. It's actually a burden on the front lot. Another type of easement is called an easement in gross. And that is an easement that crosses a number of parcels of land without necessarily benefiting any of them. And the best example I have of those is electric power lines. Electric power came to New England in the 19 teens, a little bit over 100 years ago. People had already lived here in European type settlement in English, following English property law for 300 years at that point. It was not like in the open Wild West where the government owned all the land and we could run railroads and pipelines and electric wires wherever we wanted. The land was already bought, chopped up into pieces. In order to get electrical power from the processing plants where they made it, in order to get it out to the surrounding communities, the electric companies had to string wires. In order to make that happen, they basically came out of the cities and said to the farmers, we'll pay you X amount of money, give us an easement to run electric lines across your land. You can still put your cows under it, you can still plant corn under it, and we'll even we'll wire up your farm and give you electricity on your farm as part of the deal. The farmers happily agreed to this. So in this part of the country, Rhode Island, Massachusetts, Connecticut, southern New Hampshire, most of the power lines you see exist on easements. And what the power company would have to do is they would have to get a surveyor, figure out where they wanted the power line to go, and then as they kept moving along, as they kept hitting a different piece of property, they have to go to every individual property owner and say, will you give us an easement to run our power lines across your land? And if you were to go back into the deed books over 100 years ago, you'll see sometimes pages and pages and pages of easements that the power companies collected from farmers and homeowners so they could run these electric lines across the backs of their property and provide electrical service to the outlying areas away from the cities. In the cities, they were able to utilize the streets with the permission of the city because the streets were owned and controlled by the city, either by running wires above the streets or by digging and putting wires and conduits under the streets. But once you got out of the countryside, it became a much cheaper reality to run wires in a straight line in the air, not bury them. And in order to do that, the electric companies, the power companies, spent years obtaining easements from folks. There are 4 different ways you can create an easement. All right. Now, the best way, the preferred way, is we create what's called an express agreement. Now here we're borrowing terms from contract law. When I say express, I don't mean fast, I mean express in that it was an expression. It was stated. With real estate, we're going to learn. We get to purchase and sales agreements and deeds and buying and selling that. All transactions dealing with land have to be in writing. So if we're talking about an express agreement for an easement, we're talking about a written document drawn up by the parties' lawyers where it specifically states this is what the easement is going to be. It's going to cover this piece of land. It's going to be this wide. It's going to allow for this, and this. It's going to require one party or the other to maintain the easement, to maintain the land underneath it. And you would spell it all out. You would record that in the land evidence records, and then that becomes part of the reality of the property forever. Now, easements can be created by implication. Implication is the idea that if we sell or transfer a piece of property and there are certain conditions in place that would indicate an easement is there, then the easement exists, even if we didn't discuss it. Again, go back to the idea of, in the old days, they would build 2 houses on the same house lot. Come along into the 1920s, and we have the house in front, and we have the house in back, and there is a driveway and a walkway that runs up the side of the property to the house in back. And under that driveway is the water pipe, the sewer pipe, the gas pipe. There is an electric line that runs up the driveway to get to the house and back. And the owner of the property decides he wants to give one building to each of his children. He's too cheap to go to a lawyer. He goes to the local notary public, which is usually the barber, to draw up a deed. And they say, all right, we're going to draw a line 50 feet in to the 100-foot lot. And my son Luigi gets the front lot with the house. And my daughter Louise gets the back lot with the house. The end. And we put those on record, and there it is. Luigi and Louise either die or sell the property to other people. And we now have a situation where nothing was written down. Nothing was stated. All we have is two deeds. One saying Luigi gets a 50 by 50 piece with the house in the front. Louise gets a 50 by 50 piece with the house in the back. Well, how does Louise and her successors and interests, how do they get to the back? How do they keep their electricity and their water running? And even though it was not written, by virtue of the way that that was set up, the law would say it is implied. There is an implied easement that the electric lines, the power lines, the driveway would all be as they were laid out on the ground. And therefore, even without it being specifically spelled out in her deed, Louise or whoever she sold or left the property to would have those rights. And even to the point where all of a sudden in the 1980s, cable TV comes along, or in the 1990s, Verizon and what did they use? Verizon uses the light cables, which I can't think of the name of at the moment. Fiber optic cables come along. Well, they didn't exist when the lot was divided. However, we need to run them to the back house. Well, by implication, all the earlier types of utilities ran up the side driveway. Louise or her successors and interests would have the right to say, yeah, we're also going to run the cable TV line up there, and there's nothing you in the front house can do to stop it. And in 99.9% of the situations that are like that, the court would agree and say that these easements are implied by the way the property was created and subdivided, and even though you don't have them written out, they are there. And if you need something in writing, well, you can come to court and we'll enter a court order saying, yes, they exist, and you have to allow the back property their access. They're easements of necessity. The common law, going back again 1,000 years, said that there can be no landlocked piece of land. Every piece of land has to have some access to the King's Highway so that people can go in and go out and can travel. And if a piece of land, the back 40 acres of the farm, were sold off without any indication of how we get from that out to the main road, when somebody comes along now, wants to buy the back 40 acres and put a house on it, they will have a title exam done. Whatever parcel that back 40 acres came out of, the parcel closest to it that they were part of that abuts the road has to allow them access. So there is no such thing as having a piece of property with no access. You have to have it, and particularly if you divide off a piece of land and create a parcel with no access to the roads, you run the risk that at some point somebody's going to come along who owns that parcel and demands access, and the law is going to give it to them. The fourth way that easements are created is by prescription. Easements by prescription is part of adverse possession. Adverse possession is the idea that you can acquire rights in property by using it. And we will talk about adverse possession possibly in the next handout or the next set of notes, or at least a couple of notes along. We will talk about it at length. If you have a piece of property and you consistently allow a person and a butter, or you allow the public to cross over it to get somewhere else that's not on your property, after a period of time, they can claim that they have an easement by prescription, that by using it and by not being opposed and not being stopped, that therefore they now have the right to use this in perpetuity. And the courts are very open to this. There was a furor in Rhode Island about 30 years ago because there are many, as you go down to the ocean, there are many pathways, rights of ways that existed since colonial times that allow people to get from the main streets down to the actual shoreline. And in Rhode Island, we have a very unique situation. Based on language in our charter from the king, all property lying below the mean high water mark belongs in perpetuity to the people of Rhode Island. It cannot be bought or sold, it cannot be transferred. And what that basically means is that as you're walking along the seashore, if you have 1 foot in the water and 1 foot on the sand, you are on public property. Now, over the years, that has been fudged with. There are many places where people have built buildings right out into the water, onto the water. There have been, all of downtown Providence was title lands that were filled in. And a few years ago, our Supreme Court handed out a case that gave all the title companies total paranoia, because it seemed to indicate that they were about to resurrect this right of the people and say that it was absolute and the state could never give it away, which would mean that all of the land in downtown Providence itself could never have been given to private people. It still belonged to the state. However, they backed off from that a little bit. But the idea is that in Rhode Island, you have the right to get to the shore. And over the years, many easements developed, even across people's pieces of land, to get to the shore. About 20 years ago, the Department of Environmental Management, which had been spending years having people do title exams and collecting these and trying to figure out, going out with surveyors and trying to figure out what they are, they attempted to publish a map showing where all of these easements over private property were. The furor was intense, was incredible, and as far as I know, the maps disappeared. I saw one of them once. I haven't seen one in 20-some years. However, the idea is this, that if you let people utilize your piece of property as a pathway, as a way to get somewhere else, you could at some point be prohibited from stopping them in doing that. Which is one of the reasons why, if you go walking out in the country, very often you'll see along dirt driveways, dirt roads, you'll see people have put big boulders, they'll have put no trespassing signs, they'll have run a cable across so that people can't drive up and down. Because if they've got pieces of empty property that they're not living on, they're not supervising all the time, they don't want somebody to have the ability to say, well, I crossed that land for 10 years on and off all the time to get to my other piece of land, and I now have an easement. So be aware that that is there. It is a reality. Now, affirmative easements. Easements can give somebody the right to do something. So when the easement gives you the right to bring your car over the next door neighbor's driveway, to bring your water and sewer pipe over his land, that's called an affirmative easement. It is creating a right that you have. A negative easement is an easement that can prevent you from doing something. In Bristol, there are some streets that are very, or Tiverton possibly too, there are some streets that are very, very steep, running from the main road down to the shoreline, down to the bay. And a few years ago, a developer got the idea on one of these to stop building houses. And of course, they were extremely valuable because they had views of the bay, they had views of the water. In order to keep those properties valuable, the developer put in negative easements saying that each house could only be so many feet high. And the reason for that is, by keeping the house limited to maybe 15 feet high, it did not block the view of the next house up the hill. Whereas if they were allowed to build a 4-story house, the houses further up the hill would have their views of the ocean, of the bay, blocked. That is a negative easement. So basically, it's an easement that says you can't do something with your property. You are prevented from doing it. Back in the 1950s, during the Cold War, when we and the Soviets thought we were going to nuke each other, there was actually a Nike missile base in Coventry. And there were real missiles, I think with nuclear warheads there for a period of time. And if you do titles in that part of Western Coventry, even today, if you go back far enough, you'll find in the books that the federal government came in and by eminent domain, they had to pay people, but they took trajectory easements. So they figured out as they were shooting off these rockets, we can't have a 5-story building 300 feet away from the base because a rocket will go right into it. They actually, by eminent domain, took easements over people's property, saying that, again, you can only build a building to a certain height, And there are all kinds of engineering stats in these easements to basically figure out. And I guess the further out you got, the higher the building could be, whatever. But a negative easement is one where you cannot, it prevents you from doing something with your property to benefit the people around you, the abutters. We talked about an implied easement, easement and necessity prescription. Okay. Easements can be terminated. All right. So easements generally are deemed to last forever. They're deemed to be inheritable the same way the land is inheritable. If we have an express easement that we've written out, we specifically put in that it lasts forever and it can be inherited and any future owner of the land would get it. However, we can also, in an express easement, it can expire by turn. So they can be written in provisions. Well, as of this moment, you have an easement, but if you ever put in another driveway, this easement is gone. Or if we're letting you run this water pipe across your land, but if you ever get water service from somewhere else, then the easement disappears. If it was an easement not by necessity, if the necessity ends, somebody builds a road abutting your land, and now you don't have to use the other neighbor's driveway to get in and out. By merger, if the person who owns the lot that has the benefit of the easement buys the lot that is subject to the easement, we say that the easement merges and it disappears. And by abandonment, if you stop using the easement with the intent that you no longer want to use it, you have given it up and it reverts back to the owner of the underlying property, to the owner of the fee simple. That is one that needs to be very carefully watched, because if you have a piece of property that you don't use all the time, you have to make sure that you don't do anything that would indicate that you have abandoned that easement. Because once you do, and there's no particular time involved in that, it's not like reverse prescription is one where if there was an easement by prescription, I mean, you can block it, and if you block it for 10 years, then you can say it died. Abandonment takes place immediately, and it's based on the intention of the properties. Now, one of the things that we need to talk about with easements, and it's something that is hotly contested even in today's reality, is something called the scope of the easement. We're going to talk about scope when we get into zoning as well. Scope is this idea. Think of how when you have a telescope or a periscope and you're looking at something, there's kind of this field of vision that gets wider as you go out. And depending what you do with the telescope or the periscope, you can make that field of vision narrow or wide. You can extend it or you can limit it. Well, we're kind of talking about the same concept here. Scope is how broad or how narrow is the easement. And that is something, again, and I've written a number of easements in my career, if I am writing an easement, I try to describe the scope of it as clearly as I possibly can in the written document. This is an easement allowing the passage of cars, passenger vehicles, and trucks only to the extent that they are necessary to make repairs or improvements on the benefited parcel. This easement only allows access to the benefited parcel, that no one may park their car on the easement, no one may block the easement cannot be used for digging, it cannot be dug up to place water pipes. So that we try to specifically state this is what the easement is. The problem is when you have implied easements or when you have poorly drafted easements, what happens? And an example I like to give in terms of how this would work. Let's say that, again, you bought a piece of property, you're on the main street, and you have on the left side of the property, you have a driveway going to your little garage, you have a nice backyard, and then on the right side of the property, there's another driveway that goes up to service the property behind you. And when you're looking to buy the house, the realtor says, oh, yeah, the house behind it used to be one big lot owned by one family. And when they divided it up, the back lot had no frontage. So now there's just this driveway. You own the land on the driveway, but there's an easement. But you say, oh, well, it's one family in back. That's not a big deal, not a problem. It's only 10 foot wide. It's on the edge of my property. Well, behind that back house, there's a 200-acre field. Big box store comes along and decides they want to put in one of their major retail centers on the 200 acres, and they're looking for a spot to be able to get easily in and out from the main road. And the closest connection they have to the main road, the easiest one to build on, would be using the easement on your property. So they happily go and offer $500,000 to the people in back to buy the house, tear it down, and then announce to you that they're now going to be using your 10-foot wide easement to allow 500 cars a day to go in and out of their parking lot. I think in that situation it'd be very easy to get an injunction to shut that all down and stop it, because again, even though nothing was in writing, the implied easement was that it was going to be used by a single family or multi-family residence with a few cars a day. It was not going to be used for commercial purposes or business purposes, and that you would be overburdening the easement. You would be doing something with it that was beyond its scope by now letting it be used for a commercial establishment. Again, the best way to deal with all this is, if you have an easement situation, is to put in writing or to get in writing exactly what it covers. If you don't, you're left to the vagaries of custom, tradition, and the courts to figure out what your rights are and what they are not. All right. Moving on from easements, I want to talk a little bit about restrictions and covenants. Now, private parties can create restrictions determining how land can be utilized, what can be done on the land, how it can be subdivided. What happens here is usually somebody has a big parcel of land that they're subdividing into smaller parcels. They want to make sure that that gets developed in a certain way with a certain amount of conformity. And so they will put in a set of rules, and each lot that's sold is subject to the set of rules. Now, by doing this, the developers, the people who own the property and dividing, they are holding back some rights. They're saying, we're controlling the rights as to how you're going to use this property. And they can pass that down to their heirs and successors, and sometimes it's written up in such a way that once the last parcel is sold out of the big parcel, the other owners become the holders of the rights. Now, what happens with these is that they control what you can do with a piece of property. The most common restrictions are certainly that this piece of property can only be used to build a single-family residential building. That we cannot put up an apartment building, we can't use it for commerce, we have to use it for residential purposes only. Some of them, when you get into the more expensive developments, houses have to be of a certain minimum size, they have to be set back from the road, garages have to be built, no outside laundry lines, no chicken coops, no parking of your commercial vehicles on the property. The houses, very often, they can have a requirement as to what the exterior of the houses have to look like, what type of materials can be used for paving the driveways and the walkways, whether you can have fences or not have fences, and what type of fences, and what they will look like. These restrictions can get very specific and very complicated, and it tends to be that the more expensive development that you are attempting to buy in, the greater the restrictions are going to be. And the theory on that is that we want to keep everything in this development up to a certain level, up to a certain status. That preserves the property values for all of us. And we don't want to let somebody move in and start doing things that are going to lower our property values. One of the significant cases in Rhode Island on this whole issue came down about 15 years ago, where people out in Western Cranston bought one of those big palaces that they've been building out there the last 20 years. And they had a child, and they bought a miniature pony for the child. And I believe the pony even lived in the house. However, there were restrictions in the deeds for the entire subdivision that said you were only allowed to have domestic animals, being a cat and dog, and you could only have 2 of each. Now, if the developer is no longer there and the developer is not interested in enforcing the restrictions, the other property owners have the right to enforce these restrictions. because they're there for their benefit as well. And the other property owners brought this family to court, and they sued, and the people even tried to say that the pony was a service animal, that their daughter had certain disabilities, and the miniature horse was helpful, the disabilities of that. The trial judge ruled that the horse was in effect a domestic animal, so that was okay. The Supreme Court of Rhode Island overturned that and said, no, it's not a domestic animal, it's a horse. And as a matter of fact, we don't even need to define domestic animal here because the conditions and restrictions themselves said we define domestic animals to be a cat or a dog. And therefore, they cannot own the horse. So this is something that is it can be very critical. It can be very important. It can be very unsettling to buy, particularly $1 million piece of property and find out you can't do what you want to do with it. If I end up getting involved in the process, which is not often because the realtors do not want us to get involved because we stand in the way, we slow things down, we muck things up by being lawyers and doing what we do. But if I have a client who's buying property in one of these high-end subdivisions and I can get in before the purchase and sales agreement is signed, I usually write a condition of the purchase and sales agreement saying that the whole deal is contingent upon us getting copies of the restrictions and covenants that go with the subdivision, reviewing them and determining that we like them. And if we don't like them for any reason, then my clients can get out of the deal and get their money back. If you do not do that, a word to the wise, the standard purchase and sales agreements in Rhode Island and Massachusetts that the realtors use say that you accept all normal conditions and restrictions as is. And they're not necessarily forthcoming in handing them to you when you first go to look at the house. So again, particularly if you're spending a large amount of money for a piece of property, and you may have some quirky things, you like to do backyard farming, you like to have a big vegetable garden, you do have a horse or a llama or some small animal that you've been used to keeping in your backyard, or you're one of the people that keeps home chickens now, you need to really read these before you get tied into a contract, because if you sign a standard contract, you may have waived your right to object to normal conditions, what are considered normal conditions today, and you would lose your deposit by trying to pull out of the property when you found out these conditions are not what you want to be subject to when you live there. Restrictions can also be called covenants. It's just another word for the same thing. Equitable servitudes is a fancy word for a restriction that can be enforced by adjacent owners. And in Rhode Island and Massachusetts, the rule is generally, even if the restrictions were put in place by the developer of the property as a whole, the adjacent property owners, everyone in that subdivision would be subject to the same rules and regulations. Another reason why you need a title examination done is even if the deed into your particular property does not have the rules and regulations or a reference to the rules and regulations in it, if all the other lots in the subdivision have that, you're going to be subject to it as part of a common scheme, as part of a common plan. So when we do titles to property in these subdivisions, even though our lot doesn't have the restrictions in it, we would tend to go and look, particularly it's a newer subdivision, we tend to go and look at the developer's history of the property to find what they are, because they could still be applied to our lot, even though our lot is not specifically subject to them. The other neighbors, the other property owners would have the right to see that the whole subdivision was maintained in the manner that they were told it was going to be maintained, and in the manner that their deed says it has to be retained. Again, restrictions that are restraints on alienation are generally not allowed. Discriminatory restrictions, particularly based on race, ethnic origin, religion, etc., were held to be unenforceable in the United States Supreme Court case of Shelley versus Kramer, 334 U.S. 1, 1948. So it basically said that any restrictions based on those suspect categories under the 14th Amendment, the courts are forbidden to enforce them. So it basically made them null and void. The definition of single-family use, both in zoning and in restrictions, has come under contest over the years. A particular case, a very famous case out of Ohio, dealt with the idea where a woman moved into a subdivision where I don't remember if it was the restrictions or the zoning or maybe both, because very often the zoning and the restrictions run parallel with each other and reinforce each other, said that the property was for a single family residence. And she ended up, through some circumstances, taking in several of her grandchildren and raising her grandchildren. And the lovely, wonderful, friendly neighbors decided to bring a lawsuit against her, saying that grandchildren does not constitute single family, that single family is your Leave It to Beaver, June and Ward Cleaver, husband, wife, mother, father, two kids, and that a woman raising her grandchildren did not constitute a single family. Courts did not like that argument, and they basically ruled that, and I believe this got it got at least to the Supreme Court of Ohio and into at least a federal appeals court. I'm not sure if it went to the United States Supreme Court at this point, but the basic rule came down is that whatever group of people are living together as a family, they constitute a family, and it is not the state or the neighbors wherewithal to get involved in that and to demand marriage licenses and birth certificates to see who is who or what is what. So basically, now, that being the case, could you rent out the house to a fraternity and have 30 young women or young guys or young people, college people live in it if it was restricted to single family use? I would say definitely not. However, the idea of family, as far as the courts are concerned, does not mean absolute blood relatives. It does not mean one or two generations only living in the house, that it's wider than that. Now, in Rhode Island, statutory revisions to the old common law, any restrictions created after 1953 are only valid for 30 years. Any restriction to attempt to prevent a dwelling for people who are mentally retarded or mentally disabled. Sorry, again, I have to watch my language all the time. Any restrictions trying to prevent use of property as a home for people who are mentally disabled are void, and that includes zoning and private restrictions. And any restriction or deed that just says subject to restriction of record, if those restrictions have already expired, either by statute or very often the developer will write in an end date in the restrictions when they no longer apply. Just by putting that language in the deed does not revive restrictions that have previously expired. All right, enough of that. Over and out.